Assalamualaikum to our lecturer, Professor Madia Dr. Yohani binti Yusof, and my fellow friends. Today, my group, which is Group 14, will present our assignment 2, the court case review. So, it's case Citizen Berhad versus Tribunal Tuntutan Membeli Rumah in Anor, 2019, 8 CLJ 139. This is my group members. First is my name is Nur Fatah binti Sabah. The second is Nur Aisyah binti Hamdan. Third, Nur Ain binti Ishaq, and fourth, Nurul Shamimi binti Ibrahim. The facts of this case. First is name of the case is Sotski City Sendirian Berhad versus Tribunal Tuntutan Pembeli Rumah and Anor 2019 HCLJ 139 in the High Court of Malaya at Kuala Lumpur. The judge was Azizah binti Haji Namawi J. And the parties were Sotski City Sendirian Berhad as the applicant, Tribunal Tuntutan Pembeli Rumah and Anor as the respondents. The applicant developer has filed an appeal with the court to overturn the award dated November 1 on 2018 by the first respondent, Tribunal Tuntutan Pembeli Rumah Tribunal, that enabled the second respondent's home buyer to claim of RM35,287.90 as liquidated and as curtain damages LED. The applicant filed an appeal because the home buyer lodged a petition for RM35,287.90 in liquidated and curtain damages LED with the tribunal after receiving the parcel. The tribunal granted the home buyer's request, prompting this applicant to overturn the tribunal's decision.
Issues and solution. There are three issues in this case. The developer had requested to have a solicitor represent him before tribunal, but the application was denied. And the solution is, and this because the tribunal referred to the High Court's decision in Ang Ming Lee and Os versus Menteri Kesejahteraan Bandar, Perumahan dan Kerajaan Tempatan case. So there was no legal ground to interfere with this exercise of discretion. As a result, legal counsel was not needed to argue the legal issues. Okay, the second issue, the developer had informed the home buyer of the application for an extension of time to the minister, but the home buyer had taken no action to appeal the application, so the home buyer was barred from raising it. As solution, the question of estoppel did not occur in this case because the home buyer had no legal obligation to object after being informed of the developer's request for a time extension. In terms of the home buyer, the minister had the final say on whether or not to grant the extension. However, if the minister decides to grant the extension, it will have an effect on the home buyer's right to LLD under the SPA. As a result, before the minister makes a decision that affects the home buyer's legal rights, the home buyer must be given the opportunity to be heard. Okay, the third issue is the tribunal decision was unreasonable and perverse. The solution, the minister's decision to extend the period for delivery of vacant possession from 42 to 48 months was unconstitutional because the home buyer was not granted a right to be heard before the minister made the decision. Hence, the home buyer was qualified to the LAD because there was no legitimate extension of time. As a result, the tribunal judgment could not be defined as unreasonable or perverse. So, the implication. In either case, all parties had to agree to any changes to the sale and purchase agreement, which is the SPA. Time is of the essence in relation to all terms of this agreement according to Clause A of the SPA. Given this provision and the fact that the SPA was signed by both the home buyer and developer, both parties' approval was necessary before any condition of the SPA could be changed. As a result, the time extension was null and void because the home buyer had not agreed to it. The developer failed to show that the award was unconstitutional in this case, so the court has decided to reject the appeal.
The first respondent tribunal for the home buyer is the Ministry of Urban Wellbeing, Housing and Local Government. The deadline for obtaining approval from Kementerian Kesejahteraan Bandar, Perumahan dan Kerajaan Tempatan to extend the deadline is September 11, 2013. The appeal was granted and the time was extended from 42 to 18 months. On December 1, 2016, the Ministry approved it. On September 4, the developer will hand over vacant ownership. The home buyer's appeal was granted by the tribunal and this motion seeks to reserve the ruling. In Telekom Malaysia Berhad versus Tribunal Tuntutan Pengguna and Anor 2007, one CLJ, the court held that the guiding principle on judicial reviewing relating to legislative tribunal were established on the court in Telekom Malaysia Berhad versus Tribunal Tuntutan Pengguna and Anor 2007, one CLJ. It is sufficient for me to state the principle governing the ground for maintaining a substantive notice of motion to challenge a decision-making process by way of certiorari at this time. 1. It is not a proof or a summary of ruling, but rather a review of the tribunal decision-making process to see if there are any legal error on the record. 2. Attempting an exhaustive description of what constitutes a legal error is neither feasible or desirable, since the definition of such an error are not close, and a mistake can be revealed if the decision maker, for example, A. asks the wrong question, B. considers irrelevant factor, C. fails to consider those relevant factors, and is minute error. D. misconstrues the provision of the relevant statute. E. misapplies or misstates a general legal principle.
A. Legality, which means that the decision must be based on law and the decision maker must directly understand and give effect to the law that governs has decision-making power, and whether he does or not is a justable question. B. Rational, defined as reasonably under reasonableness, which defy logic and accepts moral principle in such a way that's not reasonable person who had applied its means could consider it. And C. Procedural impropriety, which include fails to 1. follow basic principle of neutral justice, 2. At which procedural fairness, 3. follow procedure of specifically set or in the legislative instrument conferring jurisdictions, even through field does not result in a violation of neutral justice and the and proportionality and proportionality. And next, for the conclusion, based on the reasons stated, the developer failed to show the award is original. The application is hereby rejected with causes. That's all for our group. Thank you.